Any mention for unlisted matter? Any mention for unlisted matter? From the main list, item number 1.
My Lord, this case relates to the plot of land at Fire Brigade, my Lord. My Lord, the wide order dated 14/3/2023, my Lord.
Yes.
My Lord has opined that this court under Article 226, my Lord, will not decide the disputed question of facts and will relegate the parties to the appropriate forum for deciding their title.
Where is this?
My Lord, 14/3/2023, my Lord. Next page, my Lord, that is disputes, third paragraph, my Lord.
Yes.
Here, my Lord has opined that because it involves disputed question of facts, so the parties will be relegated to the appropriate forum. But at the same time, my Lord wanted to know whether this is the same plot of land, my Lord, which was gifted by Umon Lingda. Now, my Lord, an affidavit has been filed by the appellant. If my Lord can have a look at it, my Lord. It was filed on 8 May 2023, my Lord.
Yes.
If my Lord will come to page number 11, my Lord.
Yes.
My Lord, here is a map which has been, old map, my Lord, which has been enclosed. Now, if my Lord will see the below portions where these roads are joined, here there is a mention about Swiss cottage.
Yes.
And just opposite to this, my Lord, the field in triangular shape, my Lord. This is the field, my Lord, which was gifted.
Where?
My Lord, below, in the map, my Lord, if my Lord is at page number 11.
Yes. Swiss cottage is at the middle of the page.
Right. Just crossing the road, my Lord will see this one in triangular shape. One line goes and connected to this Juwai road, my Lord.
Yes.
Yes. This is the plot, my Lord, which was gifted. If my Lord will come to the next page, that is the satellite image, my Lord.
Yes.
Here also, my Lord, the position of Swiss cottage is indicated, as well as the field, my Lord. Now, here, my Lord will see one
field, the park.
One football field, my Lord, as well as one basketball court is there, my Lord.
Yes.
Now, this is the bigger portion of land which was gifted by Umon Lingda. This is measuring an area of about 1.48 acres. Whereas the greenery portion, my Lord, where the park is written, this plot, my Lord, did not belong to Umon Lingda. This belonged to Nongklau clan, my Lord. There is two plots. And these portions of the land, my Lord, was acquired, requisition initially, my Lord, subsequently, and this has been maintained by Forest Department, if I am not wrong, my Lord. So there is, after all this, my Lord, there should not be any doubt that different plot of land was gifted. This is, and whereas, my Lord, the park area, my Lord, this is only 22,000 square feet. Whereas the other portion, my Lord, it is quite bigger, 1.48 acres.
You are claiming the small land.
No, my Lord, bigger land. I was gifted with 1.48 acres of land, my Lord. And this is the field area which was given, my Lord, to me. So considering all this, my Lord, there should not be any doubt that any different plot of land was gifted.
That's a question of evidence.
Right.
That's a question of
You're
you
right,
can't
my
do
Lord.
anything about it.
So what this can go
we
to
will
the...
leave you free to institute a civil suit.
My Lord, appellants hearing, my Lord,
Actually,
they can...
what I'm aggrieved, Your Lordship,
Yes.
is nothing to do with title or anything. I'm aggrieved with Annexure D, Annexure B, which at page 26. That is the limited grievances. I want this to be done away with, and I will file a suit.
Annexure B.
Page 26 in the main read appeal, Your Lordship, memo of appeal.
Memo of appeal.
Yes. This is
This is an appeal.
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 in a main appeal.
What did the trial court do?
No, Your Lordship. Actually, I'm having a...
No. If this is an appeal, you are aggrieved by the trial court's order.
No. I'm aggrieved, Your Lordship.
Is this a writ petition or an appeal?
This is a writ appeal.
My Lord, if I can clarify...
Yes.
This is a writ appeal against the single judge order where the interim order passed by the same court, maybe another bench, was set aside and quashed. And there was an observation that this matter could be relegated to a civil court. Now my point is this, that until and unless this Annexure B, which is page 26 of my red appeal, is set aside and quashed, because this document put me in a very disadvantaged position, giving the right to respondent number 4 and 5. This is done away with, I will go to civil court.
If my lord, I can make a small submission.
What does this say?
In inviting a reference to your letter numbers also,
That being planned as per your status quo as far as usage of the ground is concerned, which includes established procedure of obtaining NOC, Darbar Strong and promotion, subject to all conditions being met. We will only, the best that we can do is that the commissioner will be responsible for the maintenance and upkeep of the land till such time that the civil court decides.
good idea.
If my lord, I can make a small submission, my lord. My lord, the order of the Deputy Commissioner, my lord, 12th November 2022, it was, my lord, given in public interest. My lord, many programs are being held even from the government side, as well as sometime Mela for the children, and my lord, the trade fair, and otherwise also the ground is used for as a playground by the children, my lord. And there is no other...
The larger area.
Larger. And no other place, my lord, in the city is available also, my lord.
No. We will say that the commissioner will not stop any play, but no fairs or anything like that.
My lord, one small submission, my lord. Now, my lord is aware that there, in the city, my lord, there is hardly any place, my lord, where even for the children, my lord, a Mela can be organized. Now, my lord, as far as Lamkra is concerned, that is the only portion of land, my lord, where sometime, even Mela is, my lord, it is of public importance. Children, my lord, they have the right even to go and enjoy this Mela, my lord. Otherwise, they will not even tomorrow.
If the title is decided against you, ultimately, then the land will not be there.
My lord, my only small submission is, as my lord has already seen, the plot of land was already gifted to Ceylon municipality, and on what context it was given.
We are not going into that.
My lord,
what we are saying is that it's not in public interest that a Mela is used over there. That's a very busy junction, that fire brigade junction. That's the fire brigade.
That is otherwise used as a playground. It is otherwise used as a playground.
It will be used as a playground.
Now, my lord, only a small submission, my lord. Now, the order of the Deputy Commissioner, my lord, why it was passed, my lord. Now, order of the Deputy Commissioner says, status quo to be maintained as it is going on, my lord, for the last so many years, that established procedure obtaining NOC from the Darbar as well as from this office should be followed. And in the meantime, what has happened is, if suppose tomorrow Darbar gives a permission to somebody to organize a trade fair or whatever maybe, some program. Now suppose Darbar cancels it. Now the other sides, my lord, they may have a claim. They may have a claim. So in such a circumstances...
No, sir. We are not grazing out in the field and come to court after that. If they have a claim, it's a supervening circumstance for which no claim will lie. It's not the fault of the Darbar. Court has stopped it. Yes. So please, don't take us to be, people who are grazing on the field before we come into the court. We have some basic intelligence also. The parties have exchanged affidavits, and it is evident that there is a serious dispute as to title pertaining to the plot of land in question. Full stop. Indeed, comma, a paragraph. In the judgment and order impugned dated February 15, 2023, the trial court
single judge.
Single bench indicated that the matter had to be relegated to a civil suit to be adjudicated by the appropriate forum full stop. However, comma, the limited ground on which the appeal has been preferred is that the previous interim order granted staying an order of the Deputy Commissioner East Khasi Hills dated November 12, 2022 was vacated by the impugned order. Full stop. According to the respondents, comma, the larger plot of land where there is a football playground and a basketball court, comma, was gifted to the Laitbukra Darbar Shnong,
To the Shillong Municipal Board, my
to the
lord.
Shillong Municipal Board, and comma, as such, comma, public have access to such land. Local boys and girls use it as a playground, and comma, at times, comma, permission is granted by the Laitmukra Darbar Shnong and the Deputy Commissioner for fairs and exhibitions to be held there, full stop. The respondents submit that such practice has gone on for years, and comma, as such, comma, till the civil dispute is decided, comma, the Deputy Commissioner required the status quo to be maintained.
My lord, no civil dispute as on today, my lord.
Required the status quo to be maintained as far as usage of the ground was concerned. Full stop. The respondents also point out that at the time that the order was passed by the Deputy Commissioner, comma, there was no real civil dispute, and it is only in course of the present proceedings that the appellant herein has sought to assert title over the land in question. Paragraph. In view of the observation in the order impugned, and it being apparent that there is a serious dispute between the appellant on the one hand and the respondents on the other,
That's 4 and 5.
respondent numbers 4 and 5 on the other, as to the title to the relevant land in question, comma, such matter cannot be conveniently addressed in proceedings under Article 226 of the Constitution by way of summary procedure and affidavit evidence. Full stop. Paragraph. Accordingly, comma, notwithstanding the limited scope of the present appeal, comma, the writ petition itself, comma, WPC number 519 of 2022 is taken up for consideration and disposed of along with WA number 5 of 2023 by leaving the appellant free to institute a civil suit in respect of the land in question full stop. As to the order of the Deputy Commissioner dated November
12 November.
12 November.
dated November 12, 2022, comma, status quo will be maintained in the sense that the land will be permitted to be used as a playground and, comma, in the very exceptional case, comma, subject to the previous permission of the Deputy Commissioner, comma, the odd fare may be allowed, comma, but this should not exceed more than 2 a year till such time that the dispute as to title is resolved by the appropriate forum, full stop. However, comma, if the appellant does not institute an appropriate suit canvassing title in respect of the land in question within a period of 3 months from date, comma, the effect of the order passed by the Deputy Commissioner on November 12, 2022 will remain undiluted, full stop, paragraph, there will be no orders to cause.
Lordship, my serious grievances is that respondent number 4 and 5 cannot be given that option.
We are giving that power only to the Deputy Commissioner.
Okay.
Only to the Deputy Commissioner. We've said with the leave of the Deputy
Because we have been given permission also from time to time.
No.
We've
It's
only said the Deputy Commissioner will grant permission. No respondent.
Much
over
obliged.
here.
Much obliged.
Lordship, I just pointed one thing. There are several proceeds
Yes.
which accrue from these exhibitions. Some provisions may be made with regard to that, because there will be some claims from both the parties with regard to the proceeds from the exhibitions.
Don't complicate matters over there. Come around, fight for it next time.
The Lordship, that indication must be there, Lordship. Deputy Commissioner will.
My lord, already
It's
reflected.
very clear. It's only given to the Deputy Commissioner
Much
and no
obliged.
more than 2 a year.
Yes. Obliged.
Okay, Lordship. Good day, Lordship.
Item number 2.
Fight is over the proceeds. That we know. Yes. Yes, madam. You are appearing for the appellant? Who is appearing for the appellant? You have to unmute yourself, madam.
Yes, my lord. I'm for the petition.
Yes. What is the appeal about? Or writ petition? What is it about?
This is, they have come against adjudication order by the Central Excise Authorities.
Is it appellable?
It is applicable. My lord.
It is appellable. Then why not an appeal, madam?
My lord, we need time to file affidavit in reply.
That we will give, but we will keep that issue open since the writ petitioners seek time to file an affidavit in reply, comma, let the matter appear 3 weeks hence. Full stop. The affidavit in reply should be filed within a fortnight from date, paragraph. This order is without prejudice to the department's contention that the order impugned is appellable and the writ petition ought not to have been filed. Full stop. Yes.
Hello.
All right.
From supplementary list, item number 1.
My lord, this matter has come before Lordship.
Yes, what is this?
My lord, this is, this concerns, my lord, the petitioner trust, my lord, owns a stretch of land, my lord, the polo grounds, my lord. Now the state government has issued a bona vacancy notification, my lord, under Article 296 of the Constitution. We have challenged that bona vacancy notice on several grounds. One of the grounds is that Article 296 itself has prospective application, not retrospective application. Here, my lord, their contention is that the land became bona vacancy in the year 1905. And they are invoking that bona vacancy now after 120 years.
So,
But that is one of the
at
grounds.
the highest, one can read it down and say, prospectively, from the date of issuance of the notice, a bona vacancy will apply. In fact, I have passed this place several times, and I used to think that this is called Sergeant, because it's written SRGT, and SRGT is short for Sergeant also. So today I see it's Shillong Recreation Ground Trust. Yes.
So, my lord,
How do you claim title?
we have purchased it, my lord.
You have purchased this. Trust has purchased.
Trust has purchased it.
When?
1902, 1903 and 1904, my lord.
From who? God.
From the local tribes, my lord. There are registered sale deeds to that.
Registered sale deed.
My lord.
Now, may I submit, my lord? In this case, my lord, what has happened that in 1903, my lord, one George Loftus Girth was solicitor of Dhaka, my lord. So he purchased 2 pieces of land, and the trust which came into existence in 1905, my lord, after 2 years. But George Loftus Girth died on 6 June 1904, my lord, and his properties could not have been part of the SRGT, my lord. And by virtue of Article 296, we have issued so-called notice only, seeking reply from the parties, my lord. So this writ is challenging the so-called only, my lord. As on today, we have not passed.
My lord, we have taken certain grounds, my lord.
What grounds?
My lord,
You know what grounds are available to show cause notice?
my lord, the ground we have
Limited
taken.
grounds.
My lord, we have taken the ground that the exercise of jurisdiction under 296. Firstly, my lord.
Very well. That ground you take, they will consider, and if they reject, you come up. How can you say? How can you come up against a show cause notice?
My lord, I have no.
There are 3 exceptions to a show cause notice.
My lord.
It's like an FIR.
My lord.
It
Natural
is
justice.
completely without jurisdiction,
My lord.
where you don't have to go into any disputed question.
My lord.
When it is absolutely fails the Wensbury test,
My lord.
or it is, otherwise, contrary to the principles, which it cannot be a show cause notice. No. We'll dismiss the petition without prejudice.
My lord, actually I was not ready, my lord. Here what happened, my lord, I was led by a senior advocate from Guwahati, my lord, DK Misra, and he is not well today, my lord.
Very well, but
My lord, if senior comes, I'll come prepared, my lord. I'll take a lordship to the.
look at my
to the
end of
background.
orders. There you'll find at least 30-40 judgments on never entered in a show cause notice.
My lord,
Unless it's been issued completely without jurisdiction,
my lord, here,
or, absolutely unreasonable.
my lord, here what has happened, my lord. The same government, my lord, took the property on lease from us, my lord, in 1979.
Maybe
My lord.
you explain all of that. They've not taken possession.
My lord, the so-called notice is issued by a person, my lord, who is a party to the pending civil suits, my lord.
Pending?
Pending civil suits.
That's all right. Take that point also. Take that point also.
Well, I'm paying some time, my lord.
We'll adjourn it today, but then please be advised that show cause notice. No way.
And there are some interim orders which have a great relevance, my lord, in this. If I point out the interim order
We'll
part.
vacate all interim orders and we'll, without prejudice, we'll do it. And we'll require them to decide the matter within, we'll give you, say, 4 weeks' time to reply, and for them to decide it within 3 months.
Well, our case, my lord, is that they are becoming a judge in their own cause, my lord.
The government can be.
But in my understanding, when they are party to the civil suit, my lord.
The government can be, the executive can be. And just because you file a civil suit does not mean that the...
We have not filed. We have filed one suit, my lord, but the ownership is challenged by some private people also of the land itself, my lord.
Very good. Since an adjournment is sought, let the matter appear a week, 10 days?
I'm a little more, my lord.
Fortnight hence?
3 weeks time.
3 weeks hence. Paragraph. Notwithstanding the matter remaining pending for some time and orders having been passed therein, prima facie, it appears that the writ petition should not have been entertained since the challenge here is to a show cause notice. Paragraph. Ordinarily, the writ court exercise a self-restraint in not entertaining a challenge to a show cause notice, since the mere issuance of a show cause notice does not cause any prejudice to the recipient of the notice, the noticee is simply required to respond to the notice, full stop. Since all material facts indicated in the present proceedings can be disclosed in response to the notice, it is unlikely that this challenge will be permitted to continue, full stop. Paragraph, it does not appear that the usual exceptions that, in extraordinary cases permit a challenge to a show cause notice to be maintained may be present in this case. Full stop. Give it a date after 3 weeks.
My lord, if I may, these observations, my lord.
I have to put you on notice. Matter has been here from 2021. The fault is ours. I'm putting you on notice today. Otherwise, one of the things that you can argue is that the court kept the matter pending and then passed interim orders, and then it said that
this ground has been taken by them, my lord.
So we are putting you on notice.
This ground has been raised by them several times, my lord. By the
when a preliminary ground is raised,
my lord,
that preliminary ground ought to be decided at the outset. For instance, in the previous matter also,
my lord,
you say appeal is there. That has to be decided, because then, if it is decided, then the person can go back to the regular forum and then do it within reasonable time. Today, if we, after 3 years of keeping the matter pending, if we decided on maintainability, then the period of limitation increases.
But here, my lord, in my humble submission, we will succeed in all 3 exceptions which are available to us, my lord. Natural justice, malafide action, my lord, of the government.
Malafide is not a ground. Malafide is not a ground. It's a complete non-existence of jurisdiction.
Lack of jurisdiction.
Natural justice is not a thing in show cause notice because you're being given notice. Natural justice is not.
Natural justice in the sense, my lord, the person who is deciding the case, he's a party to the list, my lord.
That is not natural justice. Anyway.
To be judged in his own cause, my lord, is one limb of natural justice, my lord.
Yes, in the classical sense it is. Only one matter. I thought there were several matters.
No, sir.
So let me after 3 weeks.